Hey, everybody. Welcome to Thursday night. John Skiba here with the Consumer Warrior YouTube channel. Excited to be here with you on Thursday night. Back at it. My name is John Skiba. I am an attorney in the state of Arizona. I help people who are dealing with consumer debt problems, whether it's bankruptcy, debt collection lawsuits, wage garnishments. That's what we like to talk about here on the channel, and provide you with some strategies and options and really just help you put together a plan as far as how you can deal with serious debt issues and get them in the rearview mirror and out of your life. I practice here in the state of Arizona. I've been doing this for about 22 years, a little over 2 decades, dealing with these kind of serious debt problems. And the whole purpose of here is just to give information to help alleviate some of the concerns that you may have. And like I said, give you a plan going forward. While I am a licensed attorney in the state of Arizona, I'm not licensed anywhere else. So you can't take this as legal advice. Doesn't create any attorney-client relationship, just some guy talking on YouTube. So take it for what it's worth. Before we jump into all the questions tonight, I do want to thank the sponsor of our weekly live stream, Solo. Solo, we've had the founder, George Simons. We had Yale Levy, there, one of their attorneys, on board. They have some really cool products to help you, whether it's debt settlement, filing an answer to a lawsuit, filing a motion to compel arbitration. I put a link there in the chat section. Go ahead and check it out. That's a great way to help yourself and to help out the channel. All right, back at it again. I have some big news. I wasn't here last week because my first grandchild was born last week. And so my wife and I jumped on a plane, head up to my son and my daughter-in-law's place. And hey, I have a grandkid. I'm a grandpa now, which seems kind of weird. I don't feel old enough to be a grandpa, but I guess I am. I turned 50 this year. I'm a grandfather this year. I guess I'm just getting old. I guess that's just how it goes. So here's how we do the live stream each and every week is if you have questions, go ahead, put them in the chat section, put them in if you're on Facebook, put a comment in there, or if you're on Twitter or X, put a comment in there. I'll put it up on the screen and we can talk about it. All right. Hercules was here bright and early, so we're going to jump into your questions first. This looks like a 5-part thing. 1, he says, I'm being sued by Cavalry SPV in Michigan, where I live. Michigan's 6-year statute of limitations on open accounts makes my debt time barred by January 9th, 2025. 2, but the debt is from a PayPal credit agreement stating Utah law governs, with a 4-year statute making it time barred on January 9th, 2023. Cavalry filed on December 9th, 2024, ignoring the agreement's arbitration clause by taking me to court. Will Utah's 4-year limit apply or Michigan's 6-year since they filed here? How does their failure to pursue arbitration impact this? And then he says, I filed a motion for summary disposition on the statute of limitations, contract violations, improper service, false affidavit, and non-compliance with the service order. How will that play out? Well, Hercules, I'll tell you how I think it should play out. I always say, predicting courts is a very difficult thing to do sometimes, even when you're 100% right. Sometimes the courts will rule against you. So you brought up something that's really interesting here. So, and this is something that a lot of people kind of gloss over, is if you look at the terms and conditions of a credit card, there's always a choice of law provision in there. And that choice of law states that this contract will be governed by the laws of Arizona, or like in this case, the laws of Utah will govern this. That is important. And what I have found is that courts will enforce the statute of limitations for that are referenced in the contract. So if the terms and conditions, like in your case, say there's a 4-year statute of limitations in Utah and the Utah law governs this, you can absolutely argue that. And I think you will be successful on that. Now, I can tell you that this question that you're asking, Hercules, is a lot more kind of in-depth for some jurisdictions than you might think, just as it looks how it is. And that is because a lot of this is whether it's substantive law or procedural law. And some states will say that the statute of limitations is more procedural, and so that the law of the jurisdiction where the lawsuit is being heard will rule, where others will say it's more substantive, and therefore they're going to look to the choice of law provision in the contract. Either way, argue the choice of law, argue what it says in the contract, particularly if it's a shorter statute of limitations, like in your case, and hopefully that'll help you to get it thrown out pretty quick. So, all right. Hey, just real quick, like I said, I do consultations for people who are in Arizona. I can actually represent you. If you're not in Arizona, you can still click on the link here. Arizona, non-Arizona, doesn't matter. Click on the link in the notes there or in the comment section, and we can get you set up with me or someone in your state who can help you with your issue. All right, let's see what Quinn says. What kind of questions does a trustee ask you in the meeting of creditors? So this is a bankruptcy question. In every bankruptcy case, the debtor, the consumer, has to appear at what's called the meeting of the creditors. When you think of meeting of the creditors, I mean, if you're like me, your mind kind of goes, so you're envisioning like this giant round table, and we're having a meeting with all your creditors. You have American Express, Bank of America, Citibank, all these people are sitting around a table, and they're going to grill you over this. That's not how it is at all. The meeting of creditors is a very kind of grandiose name for what it really is, which is really, nowadays it's a Zoom call with you, your bankruptcy trustee, your lawyer. Creditors can appear. To give you an idea how infrequently creditors appear, I have been practicing bankruptcy law now for almost 22 years. So over 2 decades, I've probably had a creditor appear at the meeting of creditors less than 10 times total. And I do often multiple hearings per day. And so it's very rare that a creditor is actually going to appear. But so usually what it is, it's just you, your attorney, and the bankruptcy trustee. Here's how it plays out. It's usually a 5-minute thing. The bankruptcy trustee will put you under oath. Then they're going to ask you, not your attorney, they're going to ask you a series of questions. They're going to ask you if you reviewed your bankruptcy documents prior to filing them, if you listed all your creditors, if you listed all your assets. They're going to ask you if you signed off on them. If the information in there is correct to the best of your knowledge. They'll often ask if you've lived in the jurisdiction where you're filing for at least 2 years. That impacts which exemptions you should be using. And they may ask if you have filed any prior bankruptcies in the last 8 years. You can only file a Chapter 7 bankruptcy and get a discharge once every 8 years. So they're going to ask that question. They may ask some questions about your assets. You filed all these documents, the schedules, the statements, this whole list of information. If there's information about assets that they think that they may be able to go after, you may get a couple of questions on that. They may ask you if you have any type of claim where you could sue somebody and get money, if you were in a car accident or something like that. So those are the types of questions you get. Like I said, it's usually a 5-minute meeting or less. They do a ton of these, at least here in Arizona. They start at 8 o'clock in the morning. They go all day long. And so they're just cranking these things out. So if there's a concern about an asset being liquidated, this is usually where that'll come up. They can ask about it after the fact, but that's typically what you're seeing with the meeting of creditors. I always tell people, don't lose much sleep over the meeting of creditors. I know that's easy for me to say, but almost all my clients get through with it and say, boy, that was a lot easier than I thought it would be. And it's nice because they're done via video conference. Ever since COVID, they moved that whole platform online. We used to have to go down to the courthouse, sit down there in one of the rooms in the courthouse, big full room with all these people. Now it's just done at the video call. Other people are there. That's one thing that sometimes people are a little bit surprised. In Arizona, where I practice, the bankruptcy trustees do 4 hearings every 30 minutes. And so there's usually you and then 3 other cases that are there. The questions are generally so generic that it's usually not a big deal. It's exactly those kind of questions. They're just wanting you to attest under oath that what you provided the court is accurate to the best of your knowledge. All right. Calissimo, aka Real Tax Talk, says, how often do you see debt buyers send a debt back to the original creditor after a consumer asks for validation of said debt with the debt buyer or collector? I can tell you, I don't see it a lot. It does happen, but I don't see, usually once the original creditor, and here's where you see them, or here's the scenario where you normally see it, is if the original creditor, they're not selling it, they're just hiring like a debt collector, a debt collection agency, whose job is they're just there to harass people and make phone calls and try to collect on it. that they're not actually transferring ownership. But when a debt original creditor actually sells the debt to a debt buyer, it's very rare that it actually goes back to the original creditor unless there's like some real problems with it. If there was some kind of identity theft issue or something and they're wanting to recall the debt. But it's usually what happens is it'll get sold to another debt buyer. I don't see too often that they actually recall it. So, all right, let's see. Me says, Wells Fargo apparently dished off our $30,000 debt to a local attorney 2 weeks ago. And that agency attorney sent a letter to respond within a month. The letter also stated his debt company's name. What is the minimum I should do? Just respond and state I don't recognize his association with Wells Fargo and I dispute the amount. I actually don't believe his authority with just the last 4 of our credit card and Wells Fargo in the letter. Excuse me. Yeah, I mean, I requesting validation of the debt is always a good thing. It'll not only give you some, because if you ask for validation of the debt, the Fair Debt Collection Practices Act says that they've got to provide you with that information. And not only that they've got to stop all collections while they're getting you that information. And it's also good just to see what kind of documents and information and really where they're at with the case. It can help with settlement. It can help to know, if they're going to sue you, some of the strategies you can take. So absolutely. I think that there is no problem in requesting that type of information. So, all right, let's see here. Mike says, my wife died of COVID in 2021. I am interested in the COVID lawsuit filed in Florida. Any chance gets to a settlement? You know what? That's way outside the scope. I'm sorry to hear about your situation there, but yeah, that's outside the scope of what I deal with. And particularly something like that, where there's like a class action lawsuit, you need to talk to someone there local who's handling it. Class actions are usually handled by one law firm, represents all people who are, kind of in the same situation. So I'd recommend you find someone there locally to ask that question to specifically. Cyrus says, question, I know Chapter 7 lasts 10 years on your credit, but how fast can you recover, assuming if nothing else happens? Good question. The answer is surprising. You recover from a Chapter 7 much more quickly than everybody anticipates. As soon as it gets filed with the court, you see about, the bankruptcy gets filed, you're probably seeing about 100, up to 150-point hit on your credit. It does stay on the public record section for 10 years. That information is going to be there. But as far as how long it keeps your score down and impacts lending decisions, in most cases, you have fully recovered around the 2-year mark. Mortgage loans through FHA, through the VA, you can get that 2 years after a Chapter 7 bankruptcy. And those are normal loans, normal interest rates. Other lenders, 3 years. So about 2 to 3 years, you fully recovered. But, it's always surprising to my clients when we file a bankruptcy case, they start getting in the mail advertisements for credit cards and car loans within weeks. And the interest rates aren't good, but the further you get away from that, the better you'll be. I routinely have clients who are able to get cars with pretty good interest rates, usually about a year after a bankruptcy, around 18 to 24 months. Like I say, you're on the track to where you need to be. So, I don't sugarcoat it. There's obviously consequences to a bankruptcy filing, but you're going to recover from it much more quickly than most people anticipate. All right. Grumpy Bob says, hey, John, I have a credit that's been in collections 5.5 years that I recently saved up enough to pay off the settlement. Should I pay it off, or would it be worth it to wait until the 7 years is up? If you've got the money, I would probably say just do it. Just get it out of your life. Just move on. One of those things, just kind of rip the Band-Aid off. If you saved up the money to be able to do it, you know what? Because when you pay off collections that are older like this, that, you're a year and a half away from falling off the credit anyway, depending on what state you're in, there's also statute of limitations issues because things will fall off the credit, but that means that they also could still pursue it if it's within the statute of limitations. So there's that to consider, that, you need to know whether they can actually continue to collect on it. Even though it's fallen off the credit report, they may or may not be able to, depending on that statute of limitations. But sometimes I take the approach of like, look, let's just get this thing out of our life, move on. Your credit score probably won't go up that much. It might go up a bit, but probably not a whole lot, just because the debt is somewhat older. But if it were me, just the peace of mind, that's worth something. I'd probably just go ahead and get it squared away. So, all right. Chris Brown says, during trial, what are some potential arguments a buyer would make regarding their inability or unwillingness to produce documents referenced in the bill of sale, e.g. the master purchase agreement? Okay, so good question. So just some context for those of you who may be dealing with a junk debt buyer lawsuit. These junk debt buyers, when they go to trial, they have to prove a handful of things. They not only have to prove that you had the original card, what the terms are, that you breached it, that there's damages, what the interest rates were, all that kind of stuff. They've got to show all of that to be able to show that they get a judgment. Now, as part of them trying to prove that they own the specific debt, they will often provide a document called a bill of sale. And it's usually a 1 or 2 page document. It's super generic. It just says that, hey, company A sold to debt buyer a pool of accounts or a portfolio of accounts. It doesn't list account numbers, account names, nothing like that. It usually says something like that they're attached on Exhibit A, or they're listed on Exhibit A attached here too, and then often there isn't an Exhibit A. And so that's something kind of, as far as where it, what you're going to see on that. But often it'll reference in there a master purchase and sale agreement, or a forward flow agreement, sometimes it's called. And that's actually the main document that has all the details between the two companies in that transaction. And it's a good one to request. One, they don't want to give it to you because it also has what they consider trade secrets. It shows how much they paid for all these debts. But it also goes through and it will show what, as far as some of the disclaimers, because often there's a ton of disclaimers that the original creditor is asserting or stating to the debt buyer. Like they're basically saying, if it's like Bank of America, selling some debt to Midland Funding, they're saying, hey, we don't know, Midland Funding, if any of this information is accurate. We don't know if the balances are correct. We don't know if there's bankruptcies or if it's within the statute. They do all this kind of stuff. They don't want that coming out because often when you get in trial, the debt buyer's like, yep, that's the exact amount. There's no question about it. When in reality, they don't really know that. And so if they're unwilling to produce that, one thing you can do if it's before trial, you can file a motion to compel and see if you can get the court to require them to turn it over. I've had good experience. Sometimes they'll say, well, how is it relevant? And I say, of anything, it's the most relevant. It's the most relevant document because without that document, without that master purchase and sale agreement, debt buyer, you can't even be here because this is what gives you the authority or the standing before the court to come and bring this lawsuit. Because I always remind the court again and again, the debt buyer didn't loan you any money. You didn't agree to pay them any money. They've got to be able to have documented evidence that's introduced by a witness who has some idea what they're talking about, that they actually own the account. If they can't do that, then the court's got to throw the whole thing out. So, as far as what are some of their potential arguments, they always say that it's relevance. They say we don't need it because we got the bill of sale. And 2, they say trade secrets. I have had courts do things like tell them they can redact like the purchase price. That they say that doesn't have to come into it, but that they do need to provide the document as a whole. So I would press the issue on that. If it's something where you don't have it and you're going into trial, I always tell the court, look, hey, bill of sale, here's the bill of sale. We don't even have the full document, basically this completeness, rule 106, rule 109, the rule of completeness. Essentially, if they're going to provide part of the document, they got to provide all of it, that kind of thing. So those are the kinds of things, Chris, that I would anticipate. All right. Cyrus says, thanks for answering my original question. I plan on maybe filing for bankruptcy next year. Now, even though you mentioned it lasts 10 years on your report, have you seen instances where it is removed quicker? No. I mean, I know that there's, you see things online where people say, hey, we got it. We contested it, object, whatever. legitimately it'll be there for 10 years. Even if you can get it removed, it likely will be put right back on. So even if it should be noted, even if your case gets dismissed, meaning that your case wasn't legal, that your debts weren't discharged, the case got thrown out for some reason, that'll still be there for 10 years. All right. Shanita says, Calvary had 2 cases against me, won the largest debt and lost the smaller debt. Wondering how my lawyer lost the first case. Now I'm paying them because of the judgment against me. Well, I'm glad they won the bigger. Oh, they won the bigger one and you lost the smaller one. Okay. I can tell you this. Part of it depends on the court. Part of it depends on the way that the judges do things. Here in Arizona, most of these cases are heard in the justice courts by the justice of the peace. Most of the justice of the peace in Arizona are not lawyers. And so because of that, the predictability is a little bit difficult sometimes. I tell clients this all the time. It's a little bit of the wild, wild west in some of these debt collection cases. Here in Arizona, it is at least. And so sometimes it's hard to really gauge exactly how the judge is going to rule. I have literally had 2 cases. I think the debt buyer was portfolio recovery, same client, same debt buyer, same law firms, identical, side-by-side motions for summary judgment. I had a judge deny one and grant the other one. So I don't know how that happens, but it did happen. So, all right, let's see here. Quinn says, I plan on filing Chapter 7 again due to a Midland lawsuit in mid-July. That will be 8 years since the first bankruptcy. Will that be a problem? No, as long as it's 8 years from the filing date. So not 8 years from the discharge date. As long as it's 8 years from filing to filing, you'll be fine. No issues there at all. So, all right, let's see here. Okay, I had a couple comments I wanted to talk about. This one has to do with reaffirmation agreements. This person asks, is it possible to refinance your car after a Chapter 7 with no reaffirmation agreement? So the background behind this question is if you file Chapter 7 bankruptcy and you have a car loan, the bankruptcy code says you need to reaffirm that debt. Now, what that means is that the lender is going to provide you essentially a new contract where you're going to sign off on it saying, yeah, I'm going to keep my car and I'm going to continue to be liable on it. Some people choose not to reaffirm the debt because either they're going to surrender the car and they don't want it anymore, or there is some risk in reaffirming a car loan. If you get in a car wreck down the road, or if you get into financial trouble and you can't afford it and you reaffirmed it, they could sue you, go after the balance in the event that you're not able to pay it. So is it possible, though, that you could just refinance the vehicle without a reaffirmation agreement? It's difficult. And the reason is it kind of goes back to this credit reporting thing. If a debt is not reaffirmed, even a car loan that you have to continue to pay on, when you look at your credit report, it's going to show that car lender, that the amount owed is 0. Now, they still have their lien on your car. So the practical effect, if you don't make the car payment, they're going to repossess your car and sell it, but they wouldn't be able to come after you for the balance. But so the problem is, in the eyes of the law and the creditor, technically you don't owe anything on that car, but they have lien rights, so you have to still continue to pay on it. But because of that, it makes it difficult to refinance it, particularly with the same bank. Sometimes you can refinance with other lenders, though. So that may be the best way to do it. So, all right, let's see here. Cyrus says, I have a car that has a lien on it by a credit card company that uses the car's equity to issue credit. Will the Chapter 7 erase this debt without having to give up the car? Car is 12 years old and worth $3,000. So with a car loan, if they truly have a lien on the title, if you gave a lender a lien on the title to the car, then no, the debt does not go away unless you surrender the car. However, there is a way in a Chapter 7 that you may be able to do something to significantly reduce the amount that you have to pay. It's called, in the Chapter 7, it's called redeeming the vehicle. Now, what this is, and this is only available in the Chapter 7s, but in a Chapter 7, you can pay the value of the vehicle instead of the balance owed. So, for example, here, you say the car's worth $3,000, but there's a bunch of money that's owed on it. Let's say that there's $10,000 that's owed on it. I'm just making up numbers here for you, Cyrus. And so what you could do in a Chapter 7 is you could redeem the vehicle. You file a motion to redeem. and the court would allow you to pay $3,000 instead of $10,000 for the vehicle, and then the balance is wiped out. There is a catch. The catch is you have to pay the $3,000 in a lump sum. They usually give you like 2 weeks to pay it. And so there are lenders out there who will give loans for these kind of things. There's one called 722redemption.com. I work with them quite a bit. They do redemption loans. It's a really interesting loan because you actually have to be in bankruptcy to qualify for the loan. So 722redemption.com. You can go ahead and check them out. So, all right, this was a question from the comments. It said, before I filed for bankruptcy, 2 of my credit cards were paid off in full in 2023, and both accounts are closed. Do I still need to disclose those accounts even though they're paid and closed? No. The only requirement is that you disclose all of your debts. And so, and that includes personal debts, family members, credit cards, medical bills, all that kind of stuff. In a situation like this, if you paid them off, you don't owe anything on them. No, you don't have to disclose that, and that won't be an issue at all. This one said, if I don't want to keep my car and car loan, when should I give it back? I don't want to give it back if my Chapter 7 bankruptcy isn't approved. So in a bankruptcy, if you're going to surrender the car, we've kind of talked about some of these different options. You can surrender it through the bankruptcy. There's a couple ways to do it. You could surrender it right before the bankruptcy is filed, where you just voluntarily take it back to the lender and then get rid of the debt through the bankruptcy. After the bankruptcy is filed, the lender often has to get permission from the bankruptcy court if they're going to take the car back. So they have to file what's called a motion to lift the automatic stay. If they do that, it could take anywhere from 4 to 8 weeks. And then from there, they can pick it up. And sometimes they'll just wait until the bankruptcy is over, which will take 4 to 5 months. So, so it kind of depends on your lender. You got to talk to your attorney about that. If it's something that you talk about your Chapter 7 bankruptcy not being approved, in 99.9% of cases, you will know if your bankruptcy is going to go through even before you file it, because you'll pass the means test and then you can pursue it that way. So those are some things to take a look at when it comes to cars and Chapter 7 bankruptcy. Generally, if you get in there because you meet the means test, you're going to be fine there. So, all right, we'll do one more here. Cyrus says, is it expensive to file a bankruptcy case separately from the Chapter 7 to get rid of student loans? Let's see, especially if the loans are already a decade old. I feel like Chapter 7 needs to include student loans. Yeah, student loans are still, there's a presumption under the bankruptcy code that they do not go away. See, it's federal loans, private loans, those kind of student loans, they don't go away. Is it expensive? It depends on the attorney, because what happens is you actually have to file an adversary proceeding in the Chapter 7. It's like a mini lawsuit where you're suing the Department of Education or whoever holds the loans to be able to show that there is a hardship. And so, most attorneys, it's going to vary from state to state. I can tell you it can be even more expensive than the bankruptcy filing itself because it's litigation. It just literally depends on what the attorney's charging, how complex your case is. It's something really to get an attorney to look at and see if there's a good chance they'll be eliminated and if it's worth spending the time and money to do it. So, all right, let's see here. Sheena says, John, how does bankruptcy info become public record if the court doesn't sell the information? Well, there are lists. It is public. The bankruptcy is public information. It's not like posted on a website somewhere, but there are lists, that you can get. I know this, all courts have these lists, and they do sell it. They sell the data. They're not actively marketing it, but if people want to get it, they can get those lists. So that's how it happens. So, all right, I think with that, we'll do it today. We're at a half hour. I appreciate everybody checking in. I will put in the comments one more time, if you're wanting to set up a consultation, go ahead and click on that link there. And I'd be happy to put some more things in there. I'll try to reach out to the guys later on and take care of those. Appreciate everybody checking in tonight. And with that, we'll catch you next week.